Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again with a new video on your legal affairs for your CLAT and AILET, as we have been doing this activity for a long period of time now. So you can follow all of my videos that we have done so far and have a look at them, and also find the relevant newses for yourself for your CLAT and AILET. And I've been discussing a lot of judgments and a lot of orders that have been passed, or any other reviews that have been given by the courts across the country. We always discuss those in our legal affairs so that you can go and get an in-depth review of those newses also if you want to, right? So if you haven't liked, share and subscribe button, please hit on that. If you are watching this channel, that is a mandate that you should do, so that the people who are making the videos also get motivated to make more videos. And if you are not a part of a Telegram channel and you are looking for free updates, definitely give us a share and subscribe on your Telegram channel, which is under the name of CLAT@Pratham. You can see down on your screen, the name of the Telegram channel is already written. Now, what is the first legal affair for the day? That is that the fundamental right to carry on trade under Article 19(1)(g) can be reasonably restricted if there is a public threat at large, right? So what does that mean? What is happening here? So this was basically a case where the person was trying to take a permission on a usage of LPG distribution system in his territory or in his vicinity, right? So now the person wanted to use that kind of a system. That's why this came up, and the Telangana High Court said that the executive institution, with a check on ground reality, advance the purpose of statute and act as a guiding factor for effective implementation by the state government, and also to protect the life of a common man. And it is not an infringement of a person's constitutional right to carry on trade under Article 19(1)(g), right? So that's what the court has said, very simply, because it was related to the people at large, and the purpose of that act was also to protect the public at large. Right now, if the person is not being allowed to carry on trade because it threatens the safety of a lot of people, so it is not said to be like violating the right of trade, or your right to carry on your profession, or carry on trade, right? So that's what the court has also said. If it is protecting the people at large, then it is restrictive in nature, and it can be, such kind of trade can be restricted. Okay, now coming to the next news for the day, that is that moral policing is not allowed, right? So this is what the Madhya Pradesh High Court has ordered, that is regarding a willingness of a woman to convert her religion after marriage, right? So there was a deciding a habeas corpus petition. If you guys know that habeas corpus is a kind of writ petition that is being filed, so this is the homework. You need to go and find what is the meaning of habeas corpus and what is the writ all about. Go and definitely read upon it. Now that the court was deciding on this petition of habeas corpus, the Madhya Pradesh upheld the constitutional right of a major person to stay together, either by a way of marriage or in a live-in relationship, right? So सीधा सीधा कोर्ट ने इस चीज को एक्सेप्ट किया, माना और upheld किया इसको as a constitutional right. Now there was a justice named Nandita Dubey, who was essentially dealing with the petition of moved by a husband who alleged that the parents of his wife has forcibly taken her to Banaras and have illegally detained her, right? So now the petitioner submit that he married his wife with her consent and she willingly embraced Islam, right? So that's what the court has said. So the court has told to find the person, and also said that it is her full willingness. If she has done it with full willingness, then the court has nothing to do with it, and moral policing isn't allowed, right? That's what the court has said very straightforwardly. You can see these were the words by Justice Nandita Dubey. Okay, so any person who's an adult has a sane brain can take all the decisions for their relationship with whom they want to live or whom they want to choose to live in their future, and it takes care of both by the way of marriage or live-in relationships, right? So that is something that is also being told by the Madhya Pradesh High Court in the recent order for this adult woman. Now coming to the next case, that is a right to be forgotten. As we have seen the Ashutosh case of roadies where we have discussed this, and also this is a new thing that is coming up, that is in the Delhi High Court has asked India Qanun. If you guys know, India Qanun is a website where you can find the orders and the judgments that are given by different courts all across the country. So that is the website called indiaqanun.com. Now the Delhi High Court has asked the Indian Qanun to consider blocking judgments concerning matrimonial disputes, right? So there are some places where they have given matrimonial disputes and they have been told to consider blocking the access of a trial court judgment concerning to a matrimonial dispute in a plea invoking the right to be forgotten. Okay, now this was Justice V. Kameshwar Rao who issued this petition and had sought removal of said judgments, and also along with similar matters involving the questions of right to be forgotten. Right, so this is a great step that is being taken by the court, and also it is a fundamental right. So definitely a court can take a step on that, and they can tell these kinds of organizations to remove the cases that were there. Now coming to the next part, that is that being a government employee is not a ground for grant of bail in rape cases, right? So if someone has been asked that, so then definitely you can tell them that being a government employee doesn't discharges you from any of these crimes. You will still be under the jurisdiction of Indian Penal Code and you will be charged. So the Karnataka High Court has said that being a government employee is no ground to grant bail to an accused alleged of committing rape. And also the Justice H.P. Sandesh has dismissed this petition and said that the fact the petitioner is a government employee is not a ground to enlarge him on bail when the serious offense is alleged against the petitioner. ठीक है जी, तो पिटिशनर जो थे वो गवर्नमेंट एम्प्लॉय थे, तो उन्होंने कहा कोई फर्क नहीं पड़ता अगर आप गवर्नमेंट एम्प्लॉय हो कि नहीं हो, बिकॉज द एलिगेशंस ऑफ रेप आर वेरी सीरियस एलिगेशन. दिस इज अ हीनियस ऑफेंस. So definitely they can't let you go out on bail even if you are a government employee. That doesn't matter to them. Okay. So that's what they're trying to say, and that's what you have to understand also. Now coming to the next case for the day, that is that no bar on pursuing criminal proceedings after arbitration has commenced. ठीक है, तो ऐसा कोई बार नहीं है, क्रिमिनल प्रोसीडिंग हो सकती है even if the arbitration proceedings have started. And also that the Delhi High Court directed the police to investigate the complaints launched by a non-banking finance company against one of its defaulting borrowers. Okay, now Justice Subramaniam Prasad also said that there is no bar on pursuing the criminal proceedings once arbitration has also commenced. And the bench noted that the facts on the face of the prima facie discloses commission of a cognizable offense. ठीक है, तो जब प्राइमा फेसाई फैक्ट्स देखे उन्होंने प्राइमा फेसाई, तो उन्हें समझ में आया कि देयर वाज अ कमीशन ऑफ अ कॉग्निजेबल ऑफेंस आल्सो. सो दैट इज व्हाई सच प्रोसीडिंग्स कैन बी डन. देयर इज नो बार ऑन coming up with criminal proceedings while there is an arbitration proceeding also going on. So this was what was being told by the Delhi High Court. Very interesting case. Coming to the next case, that the prisoner has no fundamental rights to conjugal relationship as a course, may seek for specific purpose like infertility treatment. ठीक है जी, तो कोई उनके पास राइट नहीं है, फंडामेंटल राइट ऐसा कोई भी कि वो कॉन्जुगल रिलेशनशिप मेंटेन करने के लिए कोई फंडामेंटल राइट नहीं दिया जाता. सो दिस इज व्हाट दैट द कोर्ट हैज सेड कि वहां पे कोई पर्पस होना चाहिए स्पेसिफिक लाइक इनफर्टिलिटी ट्रीटमेंट और सम सिमिलर रीजंस, but it should not be constituted to a fundamental right for having a conjugal right relationship. मतलब wife and husband वाले relationship के बारे में बात कर रहे हैं. The larger bench also clarified in the reference made by the division bench. Now, the pertinent judgment of the Madras High Court answered two questions. Okay. First, whether the denial of the conjugal rights to a convict would violate Article 21. ठीक है, अगर हम उसको बोले भाई तुम नहीं रख सकते अपने कॉन्जुगल राइट्स, तुम अपनी वाइफ से नहीं मिल सकते, सो क्या ये वॉयलेटिव है आर्टिकल 21 के? और सेकंड, whether the state can be directed to consider the request made by the convict for emergency leave or ordinary leave for the said purpose. ठीक है, तो कोर्ट ने क्या बोला है? सिंस द राइट ऑफ देयर स्पाउस टू हैव अ कॉन्जुगल राइट आर आल्सो इनडायरेक्टली curtailed by such denial, now the Madras High Court has examined the scope of treating the conjugal rights of a convict prisoner as fundamental rights in the case there is such right, where it would be unconditional or subject to other restrictions also. Now the court answered the above question while deciding upon the propriety of directing the state to grant emergency leave or ordinary leave to a convict for the purpose of having conjugal rights with the spouse. Okay, so that's what the court has said कि भाई ऐसे इमरजेंसी लीव और ऑर्डिनरी लीव दी जा सकती है कॉन्विक्ट को फॉर पर्पस ऑफ हैविंग अ कॉन्जुगल राइट विद देयर स्पाउस. राइट, वेरी सिंपल, वेरी नॉट एनी डिफिकल्टी इन दिस केस. आई एम प्रीटी श्योर यू हैव अंडरस्टूड इट. Now, mutual consent. Lot of things we have heard about divorce. Lot of things comes to our notice nowadays. Lot of couples are breaking up. Lot of things are happening. If it has happened with you, you can definitely read one of these cases that you will understand what it means. Now, the mutual consent divorce means when two parties decide mutually that they don't want to live together. So here the Gujarat High Court, what happens in the Hindu Act, right? Hindu Marriages Act prescribes under 13B that there has to be a cooling off period of 6 months before a divorce is granted. मतलब 6 महीना आपको साथ रहना पड़ेगा, कूल ऑफ के लिए टाइम दिया जाता है कि हाँ ऐसा हो सकता है कि you might come together again, right? But here the Gujarat High Court has said that no cooling period of is required because the waiver was for 6 months and because the person and the couple who were in question only lived with each other for 12 days. So ठीक है, 12 दिन में डिवोर्स मांगने के लिए वो आ चुके थे. So that's what the court has said, that there is no need of a cooling off period, right? Now that there was a bench of AC Joshi that observed that in the family court refusing to waive off the cooling period, therefore it was no requirement to interfere in the impugnant order of the court. ठीक है, so that is what is being said by the Gujarat High Court. ठीक है, उन्होंने रिफ्यूज कर दिया कि नहीं हो सकता ऐसा, 12 दिन रहने के बाद 6 महीने आपको रहना पड़ेगा, कूल ऑफ पीरियड है तो है, तो वेव ऑफ नहीं हो सकता, चाहे आप 1 दिन रहो, चाहे आप 12 दिन रहो, चाहे 15 दिन रहो, फर्क नहीं पड़ता. So they haven't waive off, they refuse to waive off such a cooling off period because it is a part of prescribed under the Hindu Marriages Act 13B2 of the Hindu Marriage Act. ठीक है, तो अपील किया, कोर्ट ने बोला हाँ जी सही बात है, अगर आप 12 दिन रहे तब भी आपको 6 महीने का कूलिंग ऑफ पीरियड लेना पड़ेगा बिफोर सेपरेशन, इवन इफ इट्स अ केस ऑफ म्यूचुअल कंसेंट इन डिवोर्स. राइट, सिंपल एज दैट, नथिंग वेरी डिफिकल्ट. नाउ कीपिंग पोल्ट्री बर्ड्स, ठीक है, जो चिकन वगैरह पोल्ट्री में उगता है उसके बारे में बात की जा रही है. इन बैटरी केजेस वायलेट्स देयर राइट टू लिव विद डिग्निटी. ठीक है, तो बैटरी केजेस है जो डेट्रीमेंटल है टू देयर इनहेरेंट डिग्निटी एंड राइट टू लिव पीसफुली. सो देयर वाज अ सबमिशन दैट वाज मेड बाय सीनियर एडवोकेट आनंद ग्रोवर and Krishna Venugopal before the division bench comprising of Chief Justice D.N. Patel and Jyoti Singh. And also this is what they have said is definitely unhealthy, unhygienic and perpetrating to extreme cruelty. ठीक है जी, so keeping poultry birds in such a battery operated cages and shock absorbing cages and all those things is definitely against their right to live with dignity. So that's what the court has said, and also this was in question, so definitely the answer is given to you. You can see that the court has also agreed to this and also they have challenged them. They have put a submission. Now this is it for today, guys. Thanks for joining this live session. I hope you have gotten these great news in a short span of time. I don't want to take a lot of time of you because you are preparing for your board examinations and also for your CLAT and AILET. So do make sure that you're hitting on the like button and also on the subscribe button. Don't forget to hit on the bell icon. Thanks for joining this live session. We'll see you again on Wednesday on the same place, same time and the same person, and we will discuss some new things about CLAT and AILET or anything related to the law entrance test. Thanks for joining. Take care of yourself. Don't forget to use your mask and hand sanitizers, and also maintain social distancing. If you are above 18 years of age, do get yourself vaccinated. Do take care of yourself. Thanks for joining the live session. Have a nice day. Have a great evening, and best of luck for your examinations. Bye-bye, guys.